is on the 4th. We have with us
Recording in progress.
great panelists. I would like to welcome Dr. S.C. Parekh, Dr. A.L. Meenakshi, Dr. Baljit Singh, Dr. Sunil Katyal, Dr. Suresh Bhargav, Dr. Anjali Bhure ma'am, Dr. Mahesh K. Sinha, Dr. Arun Sharma. It's a great pleasure to have you, sir. I would like to thank Rahul Chobe for live streaming this session on CAP Academic Series on Anesthesia TV. Now I would finally like to welcome our Dr. Naveen. Over to you, sir, for moderating today's session.
Thank you, Dr. Priyanka. Last week, we had an excellent webinar on the medical legal issues pertaining to the private practice. And I, once again, reciprocate the feeling of Dr. Priyanka Bansal, that Dr. S.C. Parekh, Dr. A.L. Meenakshi Sundaram, Dr. Sunil Katyal, Dr. Suresh Bhargava, Dr. Baljit Singh sir, Dr. Anjali Bhure, Dr. Mahesh Sinha, Dr. Arun Sharma, we all actively participated in the discussion. Carrying forward that thing, straightforward, last time we discussed about an arrest after spinal anesthesia and arrest after vaginal anesthesia before the incision was given. Dr. Bhargav sir, I'll put a case scenario to you. A patient had an uneventful surgery. A 40-year-old female, mild obese, 75 to 80 kgs of weight, polylithiasis, underwent lap cholecystectomy under GA with second generation supraglottic airway device. Surgery finished in 1 hour. Patient shifted to recovery room. Within half an hour or so, the nurse said that the patient is not responsive. Saturation was 80%. ABG sample was taken, which subsequently revealed PCO2 of 90. Patient was reintubated and shifted to ICU for further management. Because that nursing home didn't have an ICU. Now, you being a critical care specialist, you must be encountering such patients day in and day out who had an uneventful surgical procedure but land up in ICU in the postoperative period. So, in addition to the clinical management, sir, which will be done as per the excellent services available and your expertise, but you have to deal with the patient's attendance also. Some documentation has also been done because there is definitely an incidence of increased perioperative morbidity. And while doing this thing, safeguarding the interests of the anesthesiologist who has conducted this case. And subsequently, I'll put another question to you, which I'm telling you right now. Patient is in ICU for 2 to 3 days. Initially, patient attendants will say, sir, whatever you do, whatever it takes, save the life of the patient. But after 3 to 4 days, definitely there is cost of ICU per day. First day is more expensive and subsequently costs add on. And the attendants start getting wary of the price also, sir. So in your experience, how to deal with such a scenario once an anesthesiologist, being a critical care specialist, is there in the ICU? 3 aspects: medical management so that patient survives, managing the attendance and the documentation file, safeguarding the interest of the anesthesiologist, and third, the financial aspect. Dr. Suresh Bhargav, sir.
Thank you, Naveen. Due to unplanned ICU admission and putting patient on ventilator is really a emotional trauma to the attendants, as well as creation of the anxiety among the attendants. Now, we have to deal with the patient attendants to calm down their agony. For that, good communication skill is required among the teaching doctors, whether is an intensivist, surgeon, or anesthesiologist. Preferably, the first counseling should be done jointly by the critical care team, anesthesiologist, and surgeon after the transfer of the patient to ICU and stabilizing the patient. Our statement of each and everybody should not contradict each other. We should talk each other prior to coming to the or going to in front of the attendants. We should all discuss the thing and what really happened, and we should speak in one same statements. Now, as in the last session also, it was discussed that communication should be documented and documentation should be communicated to the patients. And our counseling should cover issues like recovery, whether patient will recover or not. How much the cost factor we should also consider, because after 2 days or 3 days, as you rightly spoken, that after 2 or 3 days, this cost factor will be there with the patient. Then duration of ventilation, duration of ICU stay on the first day. Every time when their attendants are anxious, they will definitely ask, "Doctor साहब, patient कब ठीक होगा? कितना time ventilator पे लगेगा?" शुरू में तो ये पूछते हैं, लेकिन after second day or third day, they will discuss cost also. Now, coming to the ICU communication or to the relatives, diplomacy should be essence of our counseling, but definitely there should be transparency and honesty also. Nothing should be hidden from the attendants. Now, coming to this particular case, recovery can be assured, but duration of ventilation or duration of ICU stay cannot be committed. Although in post-operative desaturation, recovery can be predicted, but it cannot be committed to the attendants, because there can be definitely some complication can arise. A patient is the mildly obese patient with there can be comorbidities with the patient, and other complication like infection, like DVT, like embolism, and so many other complications can arise after putting the patient on the ventilator. So we cannot commit the duration as well as recovery duration. Now, coming to the post-operative morbidity, as you have spoken that there can be increase in the post-operative morbidity. So in our records should be complete, and documentation in our records should be perfect, complete, and there should be minute-to-minute documentation should be there, and there should be a parity of documentation in all our records. All our record means the nursing records, the doctor's records, and our resident records. There should be complete documentation and there should be parity of that documentation. Sometimes what happens that we have started the noradrenaline at the 5:30. So there is a record is there at the 5 o'clock and 6 o'clock. And 5 o'clock blood pressure was normal, 6 o'clock blood pressure was normal. So nurses, I have seen many times, there is no record of hypertension in the nursing records. So it should be, whenever we are writing in our records that start noradrenaline, so we put the blood pressure is this. But in the same time, we should check whether nurses has written in their record also the same blood pressure at which we started the noradrenaline. So regarding the cost, yes, definitely cost is a big factor. So right from beginning, we should not commit to the attendants that regarding the cost. Definitely we can discuss with because this type of patients, we have to compromise to certain extent also, because this is the problem which happened unknowingly by our anesthesiologist or post-operative care. So regarding the cost, we should communicate right from beginning that, and we should consider to waive off certain, this cost, but we should commit that in the last payment, we will give you discounts, and we will say the administration to consider it to take the certain less amount from their bills.
Right. Thank you, sir. The good thing our anesthesiologist colleague did in this case was that immediately post-op USG was also done, which showed abdomen was clear, and he accompanied the patient in the ambulance on ventilator to the Dr. Mesh Sinha sir and Dr. Arun Sharma, you both are also in the critical care. So you like to highlight some more points on this patient who has undergone an uneventful surgery, but because of a post-operative issues related to the airway, which led on to hypoxia and hypercarbia, and ultimately reintubated and landed into the ventilator. Dr. Bhargav has nicely elaborated the approach of the anesthesiologist. A few comments from both of you, Dr. Mehshana sir and Dr. Arun Sharma.
Yeah, thank you, Dr. Naveen. Sir.
Yeah, Dr. Sinha, please.
As we say that prevention is better than cure, there are a lot of decisions of the court. Setup is very important.
Sir, your network is unstable, and I think your audio is interrupted. So I'll request you to please take care of that.
Yeah, just
yeah. Arun, in the meantime, you can come in, please.
So, Dr. Naveen, we do come across these situations when there's a surgery and the patient has acute deterioration in the post-operative period. I would say, again, the basic principles still stay the same. Stick as a team. Do not try to pass on the blames. Do not speculate. Never, the relatives will have a question why this happened, why the surgery did not go the right way. So just tell them that our basic aim at this stage is to stabilize the patient. And as and when the information would be available, the information will be passed on. I work in a corporate setup. So again, when the families do talk about the finances, we do direct them to our patient welfare department and to our administration. And the general consensus is that as of now, the focus has to be on caring for the patient. And as Dr. Bhargav said, so when the final bill is decided, the family is usually reassured that we will take care of their expenses and finances at the time when the patient is either being discharged. So when the patient is being discharged, so that's a discussion that we normally have in our ICU when we come across the situation. Thank you.
Right. Thank you, Arun. Dr. Sinha, sir?
Yeah, we have to do it. It's a continuous process of. Can you hear me? All right, no?
Yes, we can hear you.
Yeah. So it is a continuous process, communication and everything. And here the communication documentation becomes much more important than in a routine case. So a continuous rapport and involving all the people, as said, that involve the administration as early as possible. Because if it is a planned surgery and something happens, so it is difficult to explain what has happened and what will be the outcome also at the early phases, we are not knowing what is going to happen. So the total ambience and the thing, we should not talk about any cost initial phases also. I think that will be a deterrent and negative impact on that. Slowly we can then add on, and then as offered help as much as help possible to them will be a good alternative. And as it started in the beginning, smaller setups nowadays should not go and do something heroic unless it in emergency patient comes to, or emergency during the stay the patient happens. So they should take ASA grade 1 and 2 patient. Prevention is the most important thing in this. Thank you.
May I add something?
Yeah, both. Dr. Parekh and then I'll come to Dr. Baljeet, sir. Yeah, please go ahead. Dr. Parekh.
When we are communicating with the patient and relative, not patient, patient's relative, one point we should take care of, that we communicate the minimum required thing. Whatever is required, minimum we should say, because whatever we say cannot be retracted later on. If the relatives are asking any specific question, we have to tell them the honest answer. But otherwise, minimum required information should be given. So once, because you speak, then you can't retract it. Otherwise, later on, as per requirement, we'll do that. Second thing is about the records. Now, patient parameters, we have a chart in ICU, patient's parameter. So we need not have a parallel record of the doctor in that. There are columns. So there is a hypertension, against that we write that we have given some vasopressor or whatever it is. Because otherwise, definitely there will be some discrepancy if everybody is recording separate. So in the same chart, we have a column that hypotension, what is the corrective measure we have been, against that column we write. Then otherwise duplication will be there, and then somewhere some discrepancy will be there and our records will be challenged. So everybody should not have his own records separate. So we should have one combined record. And about the cost, there is no question of discussing cost at this time. Only communication is our priority is saving your patient or your relative. We are not discussing cost now. That is our priority. That is your priority. So other things we'll discuss later on. That should be the. Thank you.
Why this thing of cost came in, sir? Because the ICU is of a different hospital, and Dr. Bhargav sir will agree with me, or Dr. Arun will agree with me. In the corporate setup, they will ask on day admission itself to deposit, okay, 50,000 rupees or 1 lakh rupees. And Arun, you are in Fortis, Chandigarh, or Mohali. So what's your opinion on that? Because that's a practical thing we cannot escape.
I agree. But see, now its scenario is such that every small setup, they should have some tie-up with a trusted place where ICU facilities are available. And it should be our internal understanding that will settle everything at the end. Because you don't know what will really be the outcome. If the patient ultimately recovers, probably the relatives will be willing to pay. But if the patient does not recover, the situation will be very different. So this much understanding we should have if we are regularly referring them the cases, that please wait till the end. Don't pester the relatives to every day deposit like. And then we settle mutually, all the three parties, patient, us and the corporate.
Right.
Sir, can I speak?
Yeah, Dr. Bhargav, please.
So sometimes it becomes very difficult when patient is referred from a small nursing home to a corporate hospital. And at that time, the private nursing home always think that the corporate hospital is unnecessary charging money. The nursing home who referred the patient to you, after few days, they will not discuss about the finances for the few days, for 5 days, 6 days. But after 6 days, 7 days, suppose patient stays is prolonged, then they also started talking about this. What is the need of this antibiotic? Why are you giving the higher antibiotics? Why don't you give this antibiotic? Why are you charging more? So there cannot be, some contract signed by the small nursing home or the big nursing home. This problem always arises, and this cost factor in the corporate hospital, because corporate hospital spends, and charge differently than the private nursing homes. But in spite of, this is my personal experience, in many patients, we have saved the patient, and we have, saved the anesthesiologist also. There's a surgeon also, but later on they blamed us, the big hospitals. Dr. Arun, what is your opinion regarding this?
Sir, I'll basically share the practical situation with you. So a patient undergoes an elective surgery, develops some complications. I always feel that as an ICU person, we're always at the receiving end, because the patient is going to die either of a multi-organ dysfunction or there is going to be a secondary infection. And most of the times the surgeons would come and tell the family that the surgery was fine, everything they did was perfect. But then there is something which has happened in the ICU, and so we've lost the patient. So yes, we suffer a lot of collateral damage. So what we do I work in a setup which is a tertiary care setup. We get referred patients who are critically ill. So we try to be as transparent as possible. We document everything. We keep our communications open, which is completely transparent. And we stay away from discussing the financial matters. So as and when the family says that they're having financial issues, we usually offer a second opinion to them. So we give them a summary within 24 hours. We tell them that they can take a second opinion. We cannot predict the length of the ICU stay or the hospital stay. And we usually, or I would say most often, we never comment on the financial aspects. We clearly tell them, sir.
No, go ahead, please complete it. Go ahead, sir.
Thank you so much, sir. This is perfectly fine. Thank you.
Well, just to add a bit, I think Dr. Bhargav and Dr. Arun and of course Dr. Parekh as well have very nicely highlighted the kind of action that needs to be taken, in such a situation. Two things that I would like to mention here is one, I would suggest that we should have an opinion from a physician, because that would give the feeling to the patient's attendant that the doctor is doing all his best. The physician may not add any value to the to your line of treatment, but well, at least the patient will get attendants will definitely get a feel that yes, he is taking opinion from others in case there can be anything more that can be done about that patient to make him get well. The second is counseling. It is quite a shocking thing, or quite a demoralizing, or quite I think, a very sad thing for the patient attendants to see that a surgery where so many surgeries take place and the patients come back. And it's very difficult to swallow that fact that their patient, for them, that person is the world. I mean, for others, it may be statistics. It may be 1 in 10,000, maybe 1 in 1 lakh, or whatever. For them, that person is the only thing. So here, in case we can have some sort of counseling sessions morning and evening with the patient's attendant, be it his wife, be it the husband, uncle, brother, father, mother, whoever. And that should be documented again, because counseling and documentation is something which will give the feeling to the patient's attendants that doctors are doing their best. And this documentation I'm not much into legal matters, but I do feel that this documentation will be helpful just in case the matter goes to the court.
Sure.
So, yeah, so that's very nicely summed up. And yes, this is a practical problem of, yes, we are all on the same point that counseling should be done in a proper manner, and we should explain the patients in a reasonable, so that they are satisfied also, as well as they are, we are transparent also. And financial matters, they are practical. Dr. Arun and Dr. Suresh Bhargava sir has very rightly said they are practical issues which have to be handled in both professional as well as in a compassionate manner. Now, suppose this patient files a complaint with a medical board, and that complaint goes to the civil surgeon. He constitutes a board. Okay, this is a board of anesthesiologist, a surgeon, and a physician. Now, my question, and simultaneously a complaint is filed to the State Medical Commission also. So my question is two prongs. First question is to Dr. Mahesh Sinha sir, that you are in the medical commission and a complaint is lodged to you. What will be your advice to the anesthesiologist regarding the appearance before the commission board, regarding the preparation, regarding the provisions for the appeal? Same thing, if a medical board is there, my question to Dr. Anjali Bure and Dr. Baljit Singh sir will be that what will you advise to the doctor, as well as Dr. Meenakshi Sundaram sir? You all three are in institute and you are called as an expert. You are on the other side of the table and you are a part of the board. So what is your advice to the anesthesiologist who is going to face the inquiry, and how reasonably we can help our anesthesiologist colleague? Rather, I will be loud and clear how we can help our colleague. So Dr. Mahesh Sinha sir first, and then I'll come to Dr. Baljit Singh sir and Dr. Meenakshi Sundaram sir and Dr. Anjali Bure. Dr. Mahesh Sinha.
First of all, I would like to add on, nowadays the patients not only go to the Medical Council, Consumer Protection Act, criminal petition, they go to different commissions, other commissions, Human Rights Commission, Women's Commission. So they try to go as many places as possible. And everywhere these bodies have a different way of working. First of all, I would like to not to panic if something has happened and the process is going on. And second thing is not to avoid. What happens are sometimes in the panic, people avoid to attend the meeting. Avoiding attending meeting means that you are at loss, because the message goes that something has been done wrong. So never avoid that. all these places you go and put your facts in present of them, and your documentation and everything is good, you will be saved. So nothing to panic and nothing to avoid. That is my thing. Because many times it has happened that people didn't attend and their ex-party decision has been given against them because their point was not heard. About the medical council, the people approach to state council, and if the decision goes against them also, they have a provision to go to the National Medical Commission. And it is an online simple process, so they can file the online. And as soon as they file the petition with the National Medical Commission, they automatically the decision of the state council is state. So a lot of people are not aware. So I think they should be aware of the processes of different societies and the committees, how they work. That is my point. Thank you.
Thank you, Dr. Sinha sir, for highlighting that we should not be afraid of appearing before the things. And I'd like to quickly get a comment from Dr. Bhargav sir and Dr. Arun regarding preparation for appearing before the medical board. Like suppose the patient has had a post-op morbidity and patient was shifted to ICU, and that can have two outcomes. Patient recovers or there is an unfavorable outcome. So regarding, because everything as last time it was clear that it is documentation. So, and some references which you need to attach that, okay, this is the incidence of the complications. And so how well and how to prepare about appearing before the medical board or the medical commission.
So, can I answer, Dr. Naveen?
Yeah, you, and then I'll take our opinion of Dr. Bhargav sir also. Yeah, please.
So I would completely agree with Dr. Mahesh Sinha sir. We should not take the complaint to the medical board lightly. In fact, please take it more seriously. Do not assume that there is a medical person sitting on the other side. I think it would not be taken in the right frame of mind. In fact, at that point in time, the medical board is sitting there as an expert rather than our brothers. So we need to have complete preparation. Involve your legal counsel, because do not try to take matters into your hand and do not try to answer the reply in an emotional manner, or I would say do not answer inappropriately. You may come across a situation where you feel that your case is weak. Even in that situation, I think what is required is you have to represent yourself in a completely professional manner. So there is no space for emotions. There is no space for inappropriate reactions. On the contrary, if you've been served with a legal notice for a complaint which has been registered with the state, district, or the national commission, in that case, I think you need to prepare your documents. First and foremost, do not keep going around the hospital telling everybody that there's been a case filed against me. Do not do a loose talk. Get the file issued from your MRD department. Make note of every entry that is made in the file. In fact, it is suggested that you are supposed to make a synchronological details of all the events that have been documented in the progress notes. You need to inform your lawyer, and you also need to inform your indemnity insurance. You need to provide a copy of that notice to your insurance company also. At the same time, again, as I said, you need to involve a lawyer. You need to answer every query that has been put forward in the complaint in a parawise manner. You need to sit with your lawyer and file an answer to the complaint which has been submitted. You need to go through it again. And do not assume that the lawyer has filed an answer and that's the perfect thing. Go through it again before you sign everything. And before that answer is submitted, keep a copy of that answer which has been submitted with you. So that's the basic minimum that one needs to do if you have a complaint which has been filed against you.
But Arun, you pretty rightly said that we have to give a parawise reply, and our first reply will be the basis of our for future statement. We cannot change our stance in subsequent replies. That our first reply was this and second reply was this. So the first preparation of the documentation, parawise reply of the complaint which is given by the attendants has to be replied in the best possible manner. Dr. Bhargav sir, quick comment on that.
See, now it is not only medical now. It has become the medical legal. So as Arun Sharma rightly said, that we have to reply in a medical thinking of the legal experts also. So, and just all our reply will be dependent on our records, which is already, fixed. We cannot change any record. So from our records and with the advice of the advocate and definitely our experience, we should reply para-wise, and that's all we should do. And we should, everything as spoken by the Arun Sharma, that we should have a copy of that and everything.
Right. Thank you, sir. And
10 seconds, Dr. Naveen.
yeah, please go ahead, sir. Please.
Yeah. Well, I think the legal aspect and everything has been said so very well by Dr. Arun Sharma and Dr. Suresh Bhargav. I am just diverting a bit. I must thank Indian Society of Anesthesiologists for taking this, indemnity assurance and all that. And I think it is basically because of Dr. Naveen Malhotra's efforts that most of the ISA members are, having the benefit of that. Thank you, Dr. Naveen, and thanks to ISA for this step.
Thank you, sir. Since we are talking of professional indemnity, Dr. Anjali Bure will discuss that in detail. But Dr. Meenakshi Sundaram, sir.
Yes.
You
Yes,
are as an expert witness. You are head of the institute and an anesthesiologist of repute. And the civil surgeon sends it there. This is a complaint in which it appears to be a post-operative issue. And there is a board of surgeon, anesthesiologist, surgeon, and a physician. Now, what is your advice to the fellow colleague who is on the other side of the table?
Sir, I want...
With a clear question to you, sir. How we can help our colleague out on
the clear answer is we will help the person who has done some justifiable act. So that is the straight answer. And as Dr. Arun made it out, please, we may be friendly. The doctors may be friendly to everyone. But while they are sitting as an expert, I think they will go for a knee-jerk reaction. And most of the time, the medical board has gone against the doctor only. It is very rare to find out the medical board is taking side with the doctor, because only in gross negligence, the patient or attendant will file the complaint against the commission. So I think it is easy to convince a judge, legal person, than a medical judge. So we have to be very careful while answering that. And please, not only me, personally, I certify, I will not take sides with anyone if I am sitting as a judge. And I am sure any doctor, as we are fully qualified, intelligent people, we will never take sides once it comes to a case as a court of law. So never underestimate that the doctor will help the doctor. The doctors will help only the people who have done a justifiable act. That is a one point. But as a professional colleague, I want to inform the people who are attending the commission's inquiry, please be neatly dressed up. Be confident. While you are sitting in the chair itself, you should be confident to face the eyes of the inquiry officers. And number 3, don't bluff. Please make sure that your answers are professional. So it should not be a cooked up finding. So your answer should be professional. And if suppose a notice has been issued already and a counter affidavit is sought from you, as you said, it is para-wise remarks or legally it is para-wise remarks. But that is the foundation on which the further argument building will be built. So don't answer it on your own if a legal notice is served on you. Please always consult a lawyer, but don't brush away your responsibility. Don't shrug away your responsibility. Lawyer is there to help you legally, but you are the only one who can defend you medically. So be confident, be prepared with the records, and ask one of your professional colleague to ask questions. Please request them to act as an inquiry officer, and please throw all the questions and face all the questions. And if you are having some hiccup here and there, then you manage it how to answer. So in that way only we can advise a professional colleague. But sitting as a expert witness, definitely nobody can take sides, even if it is a commission's inquiry or in the court of law, because in the court of law, we have to prove our expert witness with the textbook. It is not that simple, because the person who has sued you, he might have taken the help of another lawyer, another doctor, and he would have gone through all the records. So there are plenty of judgments where expert witness have not been accepted by the court of law because of the ambiguity. And once it is coming to the medical judge, I want you to face the inquiry confidently with a professional approach.
Thank you, sir, for those crisp and.
Can we take up questions now? Just
Yeah,
two
please.
questions again.
1 minute, Dr. Naveen, I just want to add something about this expert witness.
Yeah, please go ahead, sir. Please go ahead, and then we'll take up the questions.
Now,
Yes.
one thing is very clear that expert witness, his opinion is only advisory. It is not binding on the court. We must always remember this. So therefore, how much help the expert can extend is limited. So you cannot just say that he has done everything what was possible and all that. Second thing is the expert witness is also subject to cross-examination by the lawyer of the opposite party. And you have to justify whatever you say to save that anesthetist or whatever it is. There have been instances where expert witness opinion has been rejected and court has referred it to its own choice of board, expert board. And on that opinion, it has given the decision. So therefore, we cannot just say that every doctor will help the doctor, because there are limitations to that. Second thing, we must always utilize this thing, because many people don't know that it is our right and privilege to produce an expert witness of our choice, who can say in the court that what we have done is okay. So once you lose that opportunity and case goes to the argument and all, then you don't have that opportunity. So everybody should utilize this privilege which is given to us, that you produce an expert witness of your choice. What else you want? So we should not forego this privilege. Many people don't know this thing, and they think that it is the duty of the court to call an expert. So its court will call. If it needs the advice of expert, it will call. But it is our privilege to produce an expert witness of our choice before the court who can defend us. Thank you.
Sir, you're absolutely right. There are two sets. One is expert witness, an expert called as a witness in a court case. And other is that you are a part of that medical board, which is constituted by the civil surgeon, and in which we often go, because we in institutes are often called to be part of that board, which is comprising of usually of three: a surgeon, anesthesiologist, and a physician, or gynecologist, anesthesiologist, and a physician, where you simply give your, first you analyze the documents, and then you listen to the attendants also, you listen to the doctor also, and then you give your inquiry committee report.
Naveen, I'd like to add one more point.
Yeah, please go ahead, Dr. Sinha.
Particularly in the consumer courts, if your senior expert gives an affidavit in your support, taking all the details, technical details, that also helps the people.
Yeah, absolutely right. So, in an institute, when we go as an expert, definitely we see the records. And as Dr. Meenakshi Sundaram sir has rightly said, that we cannot go beyond the records. But at times, records do tell us that a reasonable level of medical care was extended by the anesthesiologist. Then at that time, if the records are in favor that this complication occurred and anesthesiologist acted promptly as per the late standards, then we should not shy of writing that on the basis of records available, there appears to be no medical negligence. Right? If you think that there is a lacuna, that will be also documented. But if it is a clear-cut case in which there was a appropriate detection of the complication, proper management as per the late standards, then we have to say this is as per the records available. We should be confident enough of saying that there appears to be no medical negligence. Dr. Arun, I'll come to you. Dr. Priyanka, some questions are there in the chat box pertaining to this particular thing.
That we can take up is, can an anesthesiologist seek expert advice from ISS seniors before sending a copy of his answer?
Definitely. See, all our panelists are senior ISA office bearers in capacity of the past vice presidents and past secretaries, and all the current office bearers also, whom they have faced. Definitely, I think there is no denial of the fact. Whenever you are able to contact the ISA office bearers of your city, of your state, of national, they will definitely try to help you out. And for that, we have got our ISA legal cell also. And Dr. Parekh is an active member, Dr. Meenakshi Sundaram, and all other are those who have got a legal bent of mind. They are definitely called, and there is a button in the ISA app also, the ISA NHQ, ISA app, emergency. If you press emergency, you can immediately contact the numbers of the city branch office bearer, state branch officer bearer come. Contact by phone call, WhatsApp, email, everything is there. So you can tell them, take the number and call them. The numbers are there on the website also. And definitely nobody will deny giving a legal advice as per his or her own competency.
Now, Dr. Naveen,
yes, sir,
shall I add one thing?
Go ahead.
If a member wants to have an expert witness, they can have any one of us. But at the time of justification, they have to write why this expert witness has been brought in. So at that time, the expert witness have some qualifications. One, by age seniority. Number two, by experience seniority. And by members in accredited organizations, office bearer in accredited organizations, and working as a professor or head of institute. So we have to say why we are bringing this expert witness, but he is subjected to cross-examination by the opposite counsel.
Yes. So, next question which we can take up is, what is the difference between gross negligence and negligence like cannot intubate situation?
So, can I answer this question?
Yes, sir, please.
So, if you interpret from the perspective of a law, the gross negligence would be considered in a situation where, so the basic difference is the degree of the error which has been committed. And the gross negligence is usually used in a situation where there's a loss of life. So it has to be kept as simple as that. So whenever somebody wishes to, the complaint is filed in terms of criminal negligence. So at that point in time, the court takes a decision based upon these terminology, whether it was normal negligence or gross negligence. And a criminal negligence case only is applicable as per the law if the negligence has been of a highest order. So which would mean that the doctor acted in a way which was completely asymptomatic, I would say disempathetic, and the level of skill which was used was completely below standards.
Shall I add?
Sir.
As he has correctly pointed out, she has asked for a situation cannot intubate. If that cannot intubate situation is already predicted, and if that necessary emergency trolley has not been arranged, it is a negligence. But I will answer her question straight, whether it is gross or simple negligence. Whatever adjectives we use, gross or simple is decided by the judge, not by us. So be careful that gross, because whenever the police writes FIR, routinely he will write gross and negligence driving. Even in road traffic accident, he will write he has driven the vehicle at a high speed, careless, reckoned with. Same, because he is not aware, but he used the same line which is interpreted in law, and the word gross is decided by the court and not by us. So we can simply predict, hypothesize, this may be, that may be, but it will be decided by court in a nutshell.
Okay. So another question, how much professional indemnity one should take minimum?
That depends upon the clientele. If you are anesthetizing some big people, large scale industrialist, then you may even go for 10 crores, 20 crores, whatever it is. Now the professional organizations are moving the court. They should have a cap on the insurance amount, negligence amount, because they are simply saying you pay 20 crores, 30 crores. So it is very difficult. Now they are saying, but that depends upon the volume of case, the clientele you are doing. Everybody will be asking for minimum 1 crore. So I think even in the National Commission, if you go for at least 1 crore will be the barest minimum if you are a busy anesthesiologist. If you're anesthesia, celebrity anesthesiologist, then you have to go for 20 crores or 30 crores.
Right.
That's good. I think we
Dr.
can continue
Dr.
with the
Parakh is
discussion.
saying something, but he's muted. Dr. Parakh.
Yes. See, the way the court calculates the compensation, to me, it is very absurd. Because what they do is, what are the future likely earning of the person? Say if the person is young and is a long earning life left, they will calculate how much he would have earned and his family would have got, and that much they are asking as a compensation to be paid by doctor. And I have discussed with many lawyers this thing, and nobody could give me an answer, because I say, suppose Mukesh Ambani undergoes something and something wrong happens, who is the person who can compensate his entire future earning? So this formula is not correct. It is not. They should do something else like capping or something else. But this present formula of calculating as per the whatever the possible future earning of the patient, and that's what was done with Kunal Saha case. That is how they calculated 6 crore, and with interest it became 12 crores like that. But what do you do if suppose something happens to Adani or Ambani or something? Can anybody replace that income which he is going to earn? So this should not be the basis of calculation of compensation. Thank you.
One should check the financial status of the patient before necessizing.
Then you do it in pre-operative assessment, sir.
Yeah.
Dr. Ajit, madam, here since we are discussing about the professional indemnity, so I'll like to know your views. How important is to take professional indemnity?
Sir,
Both vis-a-vis private practitioners as well as those who are in government service.
yes, sir. Now, sir, professional indemnity scheme should be taken up by each one of us. And there are various professional indemnity schemes. There could be a private one, but these professional indemnity schemes which come up with the societies will go on the basis of no profit, no loss. I mean, if there is profit, there is less profit. And that will actually be beneficial to all of us because the premium will be less for us. So this professional indemnity scheme coming from the societies will be beneficial. Like we have Cover You as our ISA National has proposing
intermediary.
Yeah. So that will be beneficial to us because there will be many advantages to all the members which are coming up. Even IMA has got that, but we do have our Cover You professional indemnity scheme.
See, Arun, see, this is many feel that we are in government sector, so we need not need a professional indemnity. But to be honest, now is the time that even if I am in a government sector, but I have also got a professional indemnity. And Dr. Meenakshi Sundaram has rightly said, in today's scenario, at least 1 CR coverage is necessary. And yes, IS has a tie-up with ICICI through the intermediary Cover You, and the price is negotiated to less than around 9,000 or so. But more important is that are we sure that having a professional indemnity insurance gives some amount of mental peace, or there are some gray areas also?
Sir, I will answer this question. Definitely, professional indemnity will give some peace of mind because it is backed by the doctors who can act as professional expert in preparing the counter affidavit, like your IMA insurance or ISA insurance. So legally also we are safe and we should not feel that we are sidelined. We are supported by a group of people. So that is the best advantage of professional indemnity insurance. But what I request most of the time, even though it looks simple, the doctors, some of the doctors I know, once the team of experts send a counter affidavit to the particular individual, they immediately they pack it up in a new cover and send it to the petitioner without even signing the records. That is the only thing. Once some affidavit reaches them, at least they have to sign, they have to read, and they can even engage their own lawyer and they can modify. But professional indemnity will, I cannot say that it gives 100% peace of mind, because that depends upon the mentality of the individual. But definitely it gives some peace of mind.
Sir, but in some professional indemnity scheme, many a times the lawyers are fixed. In such scenarios, then it becomes difficult, because if this goes on a large scale, then sometimes the lawyer might not give that much of attention. Is it so, sir?
Yes, madam. That is the reason why, see, the standing counsel is employed by every professional body. So that the standing counsel, the dictum is he should not oppose any doctors. He should not oppose any person in that profession. So if you feel that the lawyer is overcrowded, you can engage your own lawyer. But the indemnity insurance says only if his lawyer is employed. I will say it as a government. So if the government a servant faces a legal suit, only the government pleader will appear on behalf of him. And people say they will not believe the government pleader and they think they will engage a private lawyer. But imagine if the private lawyer loses the case, the government can say, if my lawyer has been act as an advisor for you, as a counsel for you, we could have won the case. So whoever is going to compensate, we have to give them the freedom of appointing their own lawyers, because we are not going to pay for that. They are fixing the lawyer. Even if you lose, the compensation is paid by that professional indemnity person. So if you are adding your own person, you can add, but you should not replace the professional indemnity lawyer. That is important.
But
May I add?
Yeah, Dr. Parikh, sir, before I reply to Dr.
I just want to add 2 points. Number one is selection of the insurance company is very important. And we must go into the track record of their payments, because companies on some pretext or other will try to avoid their liability, because they are commercial people and they want to go into their bottom line annual profits and all these things. So track record of the company is very important. How many cases they are compensating percentage wise. That is one thing. Second is timely renewal is very important. Some good companies always give notice that your policy will expire, please get renewed. But if they don't give notice, if there is just 1 day gap, you have not renewed it, and on that one day something happens, you are not covered. So these two things we should consider when we are taking a policy.
Yeah, I'll reply to both your points and Dr. Anjali Bore. Dr. Anjali Bore, madam, the beauty of ISA endorsed insurance scheme is that you can have the lawyer of the insurance company also, but you can have your own lawyer also, for which the lawyer fees is permissible. You can have any number of cases in that particular year. See, first of all, the belief is that you take car insurance in the case of eventuality. You never want that I have taken a car insurance, so it should be, I should take a claim every year. No, we never want that. Same is the case with the professional indemnity. We never want that we should face a medical legal case and it should be compensated by the indemnity insurance scheme. But yes, if you want, and majority of the anesthesiologists will like to have their own lawyer whom they have got faith, because he or she may be the relative or maybe they are in the know house and of that particular city also. So that provision is there, and his or her fees of the lawyer will be paid by the insurance company. Renewal has to be done and the notices has to be given, and there is a thing called as retroactive date. So retroactive date is always there, but it is always better to renew your insurance in time, as we do it for our motor vehicle accidents. And there is a provision for one settlement. There's the big catch in insurance is, suppose you are covered for 1 CR, it may be written 1:2, 1:4. That means 50 lakhs, 2 incidents. So maximum cover is 50 lakhs. Or if it is written 1:4, that means your cover is 25 lakhs into 4. So it should be 1:1. N number of claims up to 1 CR. Even if there is one claim, that can be up to 1 CR. If there are 10 claims of 10 lakh, that also up to 1 CR. So these are small technical things which you have to read in between the line. And the standard statement is, please always compare your existing policy with this policy. If you find anything better, please do advise us, please do suggest us. If you think that this policy is better, then you have liberty to opt for it. Arun, I'd like to come in here. Out of court settlement. We'll take the question in the chat box also, they are coming up. But out of scene, 95% of the cases, we also know, Dr. Meenakshi Sundaram also know, Dr. Parekh also know, and you also know, they will go for out of court settlement. Ultimately, it is like that only. Out of court settlement is done by the professional indemnity insurance schemes also are ready for out of court settlement so that their image is not tarnished. And same way, we the anesthesiologists also at certain point of time are happy, okay, that medical legal case is over and the out of court settlement is there and the compensation is paid by the professional indemnity. What are your views on out of court settlement? Vis-a-vis, if we can buy peace, should we buy it? And the payment is done by the professional indemnity scheme.
Dr. Naveen, again, this is one topic where I have very limited experience, but I did check the internet. Most of the sites, and even I talked to the Cover You person. In fact, my indemnity policy was due. So when she was offering me all the benefits, I talked to her that, do you offer out-of-court settlement? She said, yes, Cover You covers for the out-of-court settlements. But when I looked up on the internet, it says that if you are looking for an out-of-court settlement, you need to seek approval from your PII, from the professional indemnity insurance company. For example, if I say मैंने out of court settlement कर लिया and then I go and talk to the insurance company, please reimburse me. So there's nothing called a reimbursement. So as soon as you're served with a notice, you need to inform the company about the fact that you are looking for an out of court settlement. You need to seek their approval. Probably they'll take approval from their own teams. And then there's a possibility that this out of court settlement can be done. But whether it actually happens or not, I'm not very sure about it. So I'll probably request the other experts to come back with this answer.
I was very clear about it that out of court settlement payment has to be done by the insurance person only, and you cannot. It will be done by them only, and the only. So it is also out of court settlement. Is also a legal process. Proper documents are signed. Dr. Meenakshi Sundaram sir will further highlight it that once we do an out-of-court settlement, maybe a time will come, like suppose ICU death has occurred and outside there is a common friend. Forget about the complaint has been filed. There is a common friend known to the doctor also and known to the patient's attendant also. He will say, okay, let's. He offers XYZ amount. And we can close this case here, and because the death has occurred, bereavement has occurred. This is a common scenario outside the nursing homes and outside the ICUs. Mm-hmm. And a death has occurred, and they have lost the livelihood, and you are also a good gentleman, good human being, good noble soul. Try to compensate something for the patient, and we will close the matter here. In those circumstances also, proper documentation is done that both the parties, without any fear, influence, prejudice, they have come to this particular complication that they will not file complaint against each other. They are withdrawing this complaint and will not file in the near future also. So there are two aspects. One is out of court settlement in a complaint, wherein it is very clear that it will be done, payment will be done by the insurance company, the indemnity insurance company, and the other one is the complaint which has not been filed yet. Dr. Meenakshi Sundaram, sir.
Yes, sir. Sir, if the out-of-court settlement is done by the insurance company, well, it could be accepted because that mental agony is avoided. But most of the times, the insurance companies will not prefer because then most of the insurers, they will go for out-of-court settlement. That is one point. So they want to drag the petitioner also to the court so that if the petitioner is frustrated, they can go for negotiation. So whether the out-of-court settlement is to be accepted or not, it depends upon so many factors. One about the mentality of the doctor, then credentials of the doctor, because somebody will be afraid that his name will be damaged, thinking that as if all the other people are not receiving any legal notice. That is the reason I used to say, if you are not receiving a legal notice, there are only two possibilities. One, you may not be practicing, or you may be a non-medical doctor. So all doctors will receive a legal notice if you are practicing. So the out-of-court settlement, it depends upon the insurance company mentality of the person who is going to decide. Some people even never approach the insurance company. They will pay on their own instead of if the insurance company is not accepting. But again, it depends upon the affordability. As a ICU person practicing for 8 years, I have never gone for an out-of-court settlement, but some sort of a gentleman agreement will be there. The patient at the time, if the patient is dead, then the attenders, they want to waive the hospital fees. So that will be done. So this is just like out-of-court settlement only. We will waive the fees. They will also go. So that doesn't matter. I have seen 3 road rocos. Again, 3 times I have seen that massive protest for that other when every time I faced only the legal battle because that is my mentality. I cannot put into your shoes that you should always fight for your cause. So it depends upon the mentality and the aptitude of the doctor. And if the professional indemnity is ready to accept the out-of-court settlement, it will be very good. But most of the time they may not accept, but the doctors want to go for out-of-court settlement.
Naveen sir, can I add, sir?
Yeah, please.
Yeah. Sir, sometimes, many a times, there are, I think, out-of-court
first thing is whether.
Yes, sir.
The first thing is whether the case is defensible or not. Out-of-court settlement will depend upon that. If the case is defensible, then there's no question of going for out-of-court settlement. But if the case looks like we cannot defend it, then the question comes. Then if the insurance company has to be first, it has to give its consent, then only it will reimburse, otherwise it will not. And if there is no insurance and in spite of insurance, we are doing at our own cost, then it is advisable to involve a lawyer who will draft the agreement legally so that later on there is no problem.
This is exactly, sir, what I was going to say, that if the intervention is done without mediation, then there is a risk. Like if we want to tag up with one of the relatives, then there is a problem that both the parties, the concerned party, the opposite party can take a U-turn. But suppose if there is mediation or a mediator which is officially been done, that is, it can be taken to the court to formalize it, and then the agreement between the two parties can be done in the court. And once the court gives a seal of approval, then it remains, that will be the final verdict of the court. That is what I wanted to add.
No, we are talking of out of court. So there
yes, out of court settlement only, sir. But if there is a mediator, practically many a times it happens that one of the patient's relative will come to us and will say ki, okay, मैं settle करा देता हूँ issues. So we have to be careful that if a patient's relative is coming, he might take money and take a U-turn. That is what I wanted to add.
That's why you involve your lawyer. You involve your lawyer for that reason.
Yeah.
And then there are arbitration tribunals also, which are not like a court, but they do this arbitration between the parties and settle the matters.
Yes, sir.
But madam, usually this out-of-court settlement is done by the local thugs. They only motivate the person. So as you said, that third-party mediation is necessary. Definitely everyone with the common sense, they will be doing that. But as you say, the draft has to be approved, then it has to go to court of law and all that and all. We need not go for that. If once the person is coming for settlement, he will behave in a gentleman way only. Only the cost varies. He may be asking 20 lakhs, we will offer 5 lakhs, then it will come the thing. So that and all will not produce problem, madam. Out of court settlement through a third party will not create any problem.
Okay.
And here, sir, one more important thing is that we should not panic. We should be not in a hurry to buy peace, have patience. Because with patience, tempers also cool down and the negotiations also become easier. When the sentiments are high in the initial month or the weeks, so it is always better to wait for an appropriate time so that you don't, maximum consolation and some compensation is given to the attendants and you don't have to pay a booty for that. Dr. Vipul Shah has raised hand, and then I request Priyanka to take the question in the chat box. Dr. Vipul Shah, please go ahead.
Yeah. Dr. Parag and Dr. Malhotra, sir, you have rightly said, if the case is defendable, then don't go for outside settlement. What happens? The claiming party, the lawyer also knows that we are going to lose. Then that lawyer insists the claim party that go for outside settlement. So if we are confident and if we have not done anything wrong, then don't go for outside settlement. In majority of cases, what happens after 2 or 3 sessions, that party doesn't come for the presentation. And automatically, if their lawyer doesn't appear for 2 or 3 sessions, case automatically disappears. So please don't do for outside settlement if you are have a complete record and you are confident that you haven't done anything wrong. Otherwise, what will happen? At the last, you pay whatever the patient has paid. These are the words of their lawyer. Please, sir, pay whatever you have taken from the patient. So please don't try to go for outside settlement. This is my experience in 1 or 2 cases.
So that means if out-of-court settlement has to be done, it has to be done very wisely, very judiciously, taking into account all the pros and cons and the defensibility of the case. Dr. Priyanka?
It also gives a negative impression of our profession. When we are going for outside settlement, it means that we are a culprit. This is the image going in the society.
The other way around is, sir, that majority of the patients, attendants themselves also, sir, if they are not instigated by the lawyers, they are also, once the feeling sinks in that, okay, we have lost our colleague or of a relative,
right.
So we should get some financial benefits. One is Dr. Meenakshi Sundaram has already highlighted waive of the hospital bills, and that usually is done. I think that's a common practice. Dr. Meenakshi Sundaram sir has highlighted the waiver of the surgical anesthesia fee or waiver of the ICU charges, and then there comes a point where the attendants want some sort of financial support. Initially, the amount is very rightly said, maybe 20, 25, 50, and then as the tempers cool down, it comes a reasonable amount wherein both parties can agree. And if you're covered by professional indemnity, with their consent, you don't have to spend something from your own pocket, and it can come to a mutual, reasonable solution. But whenever the solution comes, it should be black and white, documented in bold letters, that this compromise is done without any fear, without any pressure, without any prejudice, and it won't be opened up in future for all intents and purposes. Dr. Priyanka, please.
Okay, the first question which we'll take up is how the principle of res ipsa liquidae applicable in the case of negligence in MSc?
Pardon? What is the question?
Principle of res ipsa liquidae.
So res ipsa loquitur is a thing speak for itself. So if a person walking inside the hospital discharged with one leg amputated, then definitely there is a problem with the hospital. So there should be it should be obvious. Just like we say, when there is an injury in the hand, we need not have a magnifying glass to see that. So this is exactly res ipsa loquitur. So the thing should speak for itself. That means it is a gross violation. You don't have any defense. That is the meaning. So at that particular point of time, if out of court compensation comes, we have to accept.
Yes. Next question is ISA sponsored professional indemnity reliable? Can we depend on that in case of need?
See, I'll answer that, sir. See, yes. ISA has endorsed an insurance scheme. ISA is a body dedicated to clinics, research, and academics. ISA does not sell professional indemnity. The best of the brains have worked out with the insurance company and formulated a policy. The standard statement is, please compare your existing policy with this policy. If you find that your policy is better in certain terms, please inform ISA office bearers. Those better points will be incorporated in this policy. If you find that this policy is better than your existing policy, then you are free to take it, but please read offer documents carefully before investing. But this has, over the last 4 years, around 7,000 members have taken it, and now this has, the homework done by the ISA office bearers has been utilized, and this policy has been endorsed by IMA, Indian Society for Critical Care Medicine, Indian Society for Study of Pain, AOA, IAPA, and other things. But you please go to the website, satisfy yourself, and then take this policy, because you should read the details of the services which are there. Like if they are saying that you can have your own lawyer, so it is better to have your own lawyer of your own city on the panel, because see, Dr. Meenakshi Sundaram will agree. The filing of applications, reply to the notice will be different in Tamil Nadu, will be different in Kerala, and will be different in Haryana and Delhi. Language will be different, style will be different, how to appear in the court will be different. So it is always better, rather than to have a national lawyer, to have a lawyer of your, like Lucknow. They took a policy of around 100 people together, and they wanted that particular lawyer to defend their case always. So there's a process that doctor comes on the panel of the insurance company, and you are also satisfied, and they are also satisfied. The lawyer fees comes from the insurance company. He knows that these are the doctors whom I have to defend. So, but yes, it is a good one with the track record of 4 years, but it is always better to have more suggestions, constructive criticism also, and so that there is always a process of improvisation.
If a broad dead patient is brought, should we take that patient just for the sake of declaring flatline ECG?
No, it is not mandatory. It is not mandatory. See, most of the times they are doing it like that. See, that is one, that is waste of resources, one. Number
Yes.
two, sometimes the attendant may say, you have connected the patient to some electricity. That is the reason why the patient is dead, because our patients, they will come like a mob. Number three, see, we are solid clinicians. If we don't have a clinical expertise, then can't even certify death, because most of the time people are wasting resources. So we should be confident of certifying death. It is not mandatory. That's what I want to say.
Is professional insurance required for both the doctor and the hospital staff? Actually, two people have asked the same question. Do insurance companies, the insurance company usually say that both are required for the doctor as well as the hospital staff?
See, as far as we anesthesiologists are concerned, we anesthesiologists need to have our own personal indemnity insurance scheme as a professional. But suppose we are an owner of a hospital. Well, see, 95% of the anesthesiologists will be working in their individual capacity as a professional person. 5% will have their own hospital. So any owner of the hospital, it is always better to take for the hospital also, for the staff also. So that is a different thing. But for anesthesiologist, having professional insurance indemnity scheme for self is sufficient.
What is the minimum requirement for a small nursing home like 5 beds? Is ventilator a must?
Madam, whatever may be the number of bed, life is a life. So as the ventilator is mentioned, ventilator is compulsory, especially if you are taking up surgical cases. It is compulsory. Number of beds is not at all
does not decide.
Contributing factor to that. You should have hospital is a hospital. Number of beds different from area to area, but a hospital is a hospital.
How so that answers most of the question. People are asking about cover you also is there. Do they give a lawyer in the court? But I think so that is for the company.
We already said that out of court settlement and lawyer panel. See, all those things are documented. So it is always better to read also or have a city level webinar to satisfy all these questions. Because if it is the duty of the representative to explain all the benefits. The groundwork is done, that is all documented, but it is the duty of the intermediary to explain all the benefits. Arun, you have said something?
Naveen, we had a discussion many years ago about something when we reconnected. The discussion was that the anesthesia is no longer the unsafe anesthesia that we saw about 30 years ago, and we still are paying about 3 times the insurance which any other specialty would be paying. And you did tell me that you've negotiated, in fact, the ISA has negotiated one of the best premiums that as an anesthesiologist we may need to pay. Since we have all the seniors on this platform, can we put forward our case saying that anesthesiologists should not be paying 3 times the insurance which any other specialty is paying?
That's a very good point you have raised. See, the thing is that yes, it is many people think that it is a quite economical professional indemnity. So is it really worth it? Because we have extracted the maximum benefit from them and asked them to give the best things. And maybe in due course of time we can extract better also. But yes, you are right. Like Indian Society of Study of Pain, I am a pain physician also. If I take a professional indemnity as a pain physician, not as an anesthesiologist, my charges is around 5,500. Right? But if I take a pain physician who is an anesthesiologist, my charges are 9,500. Right? So yes, if as soon as anesthesiologists come in, and yes, it is a very right time. We have already said that now we can always document that the anesthesia in 80s and 90s with the efforts of Dr. Baljit Singh sir, Dr. Meenakshi Sundaram sir, Dr. Parekh sir, and all our respected seniors, it has become very, very safe now. So it's high time that the mindset
Premiums need to go down.
Mindset of the IRDA that anesthesia and plastic surgery has to be the maximum priced, and then surgeon, gynecologist, and physicians, and then the MBBS doctors. So these are the 3 broad slabs. So I think this is a good thought and work for us to.
Dr. Naveen, the principle of any insurance is sharing the loss of fewer people by more and more number of people. So what I feel, if more number join the insurance bandwagon, then automatically the price may come down. But again, comparing to treating a fever and comparing a person undergoing anesthesia, definitely anesthesia is a riskier field. So I think the insurance company will not reduce their charges, but we can increase our charges. It is within our purview.
Naveen, I would like to add one point.
Go ahead, sir, please.
In the West, the insurance premium of anesthesiology has gone down with the time actually. But in our country, they are adopted the old regime. It was working there. Actually, they have a way of calculation, means what the premium you are paying and how many cases are coming up in a year or something like. They calculate and then how much is risk to them also. We are taking for our risk, but they calculate their risk of profit and loss, and on that basis they do this all premium thing. So we can, yes, we can ask for, but now anesthesia is much more safer. So this should be reduced.
Right, sir. Right, sir. Deepika, there are more questions in the chat box. If you can take them and so that we can answer them quickly. Okay, Doctor. Yes, Deepika. Priyanka, sorry.
So mostly cover your questions we have taken. And there is
some Dr. Bhavesh is writing that we would like to have ideal notes written and maintained by experts for reference in elective and emergency or high risk cases. Thank you. So Arun, this is the second food of thought, prototype notes. So
there is a question, sir. If there is no ventilator available in the hospital we are working or some on call we go, does the onus falls on us, the anesthetist or the hospital?
Yes, it falls on the anesthesiologist also, because the Gujarat judgment is there. As defibrillator is not available, the anesthesiologist recorded defibrillator is not available. So the court has given a clear verdict. If the defibrillator is not available, she could have referred the case. She could have refused the case. She could have explained it to the patient and the attendants beforehand and recorded. So if some machine, that too, leave alone the legal battle. See, ventilator is a must. Defibrillator is a must. As a doctor, I am saying. So instead of talking about legal things, these are all the anesthesiologist is responsible. If the patient is not recovering from anesthesia, what you will do?
Cardiac surgery is post-cardiac surgery. Patient gets a cerebral stroke. The result in partial paralysis. Should anesthesiologists also be sued? Can attendants sue the anesthesiologist too?
But any post-operative event, the entire team will be sued. Any post-operative event, because they don't know who is at fault. So they will sue all the people, hospital, anesthesiologist, and surgeon. Then it is up to everyone to defend them. But naturally, preferably, they should oppose the case as a unit, not as a different people. As a unit, these three should join together and fight for the case.
If we don't do investigations, for example, or some investigations are missing and we give GA, something happens to the patient or inadvertently, then is this an offense?
The court has given clear verdict. It expects only average intelligence, just like any average anesthesiologist in that particular area does. They expect only that type of care, the standard care. So if any one anesthesiologist says this investigation is mandatory and if it has not been done, it will amount to negligence. So it is very clear. They expect not the skill of Dr. Naveen Malhotra. They expect the skill of at least Dr. Meena Sundaram. That is court.
No, sir. Anyhow, thank you for answering. Some hospitals have no ETCO2. Is it a liable one in case of problem arises? Yes. If you're doing GA, now it is mandatory to have an ETCO2. No doubts about that. And Dr. Vijay Tyagi is asking, is pain physician a recognized term by MC or NMC? The pain procedures done by anesthesiologist, they are recognized and they are covered by the insurance company also. And many nursing homes don't have a proper workstations. Many are reluctant to anesthetic concerns, how to handle. So I think Dr. Baljeet Singh sir can take that question.
What was that? Sorry.
Many nursing homes do not have a proper workstations, how to handle them.
Has already
Well, this comes again, just like we were discussing about the ventilator. I think it is very much essential these days that we must have a working anesthesia, a good anesthesia working station with all the monitors and of course a ventilator present, because the times have changed. There was a time long back when Morton just gave anesthesia from just a small, improvised device. And now, of course, in the present times when we are giving anesthesia, we must maintain the minimum monitoring standards which are endorsed by the Indian Society of Anesthesiologists. And of course, we must try to maintain the level of monitoring which is universally accepted and, entitled carbon dioxide, as you just said, we must have. I would say yes, anesthesia workstation with monitors and ventilator must be there.
Sunil, you have asked a question. Please unmute yourself. Dr. Sunil Mehta. He has asked, are we supposed to take indemnity insurance for anesthesia, pain, or critical care individually, or does indemnity covers all the three together? See, if you take it as an anesthesiologist, it is clear-cut documented, whatever type of anesthesia you're doing, whether ops anesthesia, whether pediatric anesthesia, whether critical care, whether pain, whether general anesthesia, whether orthopedics anesthesia, onco anesthesia, all are covered.
So there is another question about how about MRI centers? They do not have MRI compatible monitors, and should we buy our own? That won't be possible in every case.
Madam, time and again it has been stressed. If there is any inadequate infrastructure, you are not supposed to anesthetize. So these sort of blanket questions, how many questions are there? If there is an inadequate infrastructure, you should refuse. People routinely say we have been pressurized, they are not having the MRI compatible bile separators. See, MRI, they are purchasing to the tune of 2 crores to 5 crores. What is a big thing in purchasing a bile separator? Yes. But if something happens, definitely anesthesiologist will be sued and he is negligent. So never venture here afterwards. We are not supposed to even think of giving anesthesia without adequate infrastructure. That days are over.
Absolutely.
We should always know when to say no. In fact, sir, our pass out PGs also, they sometimes ask, I always tell them that it is best to say no when you are not comfortable giving it.
You should learn how to say no.
Yes.
Yes.
Thank you. And now the MRI compatible equipments prices have also gone down. So it's not that costly.
But still, I think, Dr. Sinha, it costs around 50 to 20 lakhs.
No, they have gone down to really 2-3 lakhs levels.
Well, maybe some local made, but I would suggest that, if the person is investing, as Dr. Meenakshi said, crores of rupees for an MRI suite, I think this is peanuts. The cost of NRCF workstation, which is MRI compatible, is peanuts. So we should not compromise on that. We must stress on that. Yes, we have to have this monitor, this NRCF workstation and the monitor inside the MRI room before we take up such cases.
And the cost of anesthesia setup is interest of the amount spent, 2 to 3 months interest only. Very rightly said, Dr. Meenakshi Sundaram. Galaxy Tab AB, you can express yourself. The final question to all the panelists is PCPNDT and anesthesiologist.
Pardon?
It didn't get it. Please say again.
PCPNDT Act and anesthesiologist.
Okay.
Right. So nowadays we are using ultrasound. Galaxy Tab A8. Please go ahead if you want to ask any question. Okay, you are driving, so we'll get back to you. So nowadays, majority of the institutes, majority of the hospitals, they are going for USG machines. And a common question which is asked by our anesthesiologist colleagues is, do we require any sort of certification or examination before applying for PCPNDT? Are we required to take a PCPNDT? And if we are required, can we get some exemption? If we cannot get exemption, what is the procedure? So anybody of you can take up this question and answer, because USG is now used for acute pain, chronic pain, regional anesthesia, ICU, focus, and everywhere.
I will take up this question, Dr. Naveen, because I am having a first-hand experience in this. See, actually, anybody using ultrasound machine, he will be covered under PCPNDT Act. Even I am also not aware that anesthesiologists are not certified, but they are doing ultrasound guided nerve block. So I want to give importance to Dr. Bhaskar, our former secretary of Tamil Nadu ISA. He only brought it to my notice that anesthesiologists are doing USG guided nerve block, but they are not ultrasound certified. Then, just because he said, I moved the resolution in the Senate of Tamil Nadu MGR Medical University, and we have got 15 days posting in radiology for the anesthesiology postgraduates. So now they are going for postings 15 days anesthesiology, which will be used as a certification for them to use the machine. But all the other people who are practicing, definitely they will be covered under this act. Now Tamil Nadu is giving 3 months short-term course for this PCPNDT Act. And if suppose someone is suing, even when I conducted ultrasound guided nerve block workshop, where Dr. Naveen was a coordinator for that, we have even obtained permission from the Joint Director of Health Services to mobilize 10 machines, because I don't want me to be labeled as a person who has tested, even though we have even selected all male volunteers, not even female volunteers. Naveen would have seen. We have to be careful. That's all. We have to be careful. So if you are 100% genuine, you can defend yourself in the court of law. But legally, a certification is must, because court believes only in certification.
Anybody
Even our ISA professional body
Yes.
can give that.
I have came across a case by Mumbai High Court. It's about these machines generally have to be kept in the same premises. But now they have said that portable machines can be taken to different premises, provided there is some device, they call it silent observer, SIOB. Because it is like a data recorder, like a black box of an aeroplane. So it is written that if that is incorporated in the machine, it can be used for other purposes and it can be taken to other premises also, because data is all recorded there and it can be anytime verified what you have done and what you have not done. That was the judgment of a Bombay High Court, in which anesthetist was a party.
Sir, as Sir has rightly pointed out, see, PCPNDT Act requires certificates for 3. 1, a person who is operating. Number 2, a machine which is used. Number 3, the place in which it is used. That is the reason why, as I am not having a monitor, we are obtaining permission from the Joint Director of Health Services that we are mobilizing 10 machines to have this workshop. male volunteers will be done. Because now remember, 3 certificates required: a person who is operating, a machine which is being operated, and the place which is housing the machine. These 3 certificates must.
Right. Dr. Sinha, you wanted to say something?
Yeah. What I wanted to say, Meenakshi said, actually, I'd like to add one more point. That anesthesiologists can get an exemption certificate as an operator because they are not doing it. Basically, the issue is the PCP&DT, the obstetric ultrasound. So they get an exemption certificate and they can do sonography. And another thing is the cardiologists also get that certificate because they are also using the EPO, that is an advanced ultrasound machine.
Right. So Dr. Mahesh Sinha, sir, I'll agree to you on this aspect is that since I am working in an institute and we have taken PCP, see, one question is very, very clear that yes, if you want to buy an ultrasound machine, whether you are anesthesiologist or any other specialist, you have to take a PCP&DT certificate and license for that. As simple as that. And that will cover all the 3 parts: the machine, the operator, operators. Like in our institute, we have given the names, affidavits of all the professors and associate professors and assistant professors who are operating that machine, along with their MD certificates and their registration certificates, along with their affidavit with the photograph affixed. So it comes in the name of the operators and the place also. Right? It will be used for the SOT 4th floor or 3rd floor, like that. Same way we are using TEE probe also in cardiac anesthesia, where again there is a license for that. We're using it for doing in the perioperative period, intraoperative period for the cardiac patients. So as an anesthesiologist, you can take a PCP&DT clearance. No need for a proper formal training or certification, because for the procedure which you are doing, if you are doing a chronic pain blocks, you are basically localizing the anatomic structures. Acute pain blocks, you are localizing the anatomic structures. For heart, lung, you are seeing the progress of the thing. The only gray area comes in ICU where you do a procedure and based on that procedure, you change your intervention. So I did this particular procedure there was abdominal pressure was this, and I changed my treatment modality according to that. Whether that is defensible in the court of law is still a gray zone. But for majority of the instances, we the anesthesiologists are using USG machine as for localizing of anatomical structures, be it the nerves or the vessels or the study of the anatomy of the lungs and the heart and the abdomen and so forth. So you are legally competent to take a PCP&DT certificates. If you want to conduct a CME or a workshop on ultrasound in your institute, you will have to take a PCP for that. Okay, these 5 machines are coming. These will be the operators, and it will be done in this particular way, as has been done in majority of the things. So, but if you say that we anesthesiologists, ISS should do something, that there should not be any need for any PCP&DT clearance, there should be exemption for anesthesiologists. At present, it looks unlikely. Thank you very much.
Thank you, all the panelists. And indeed, it was a very good session. And to conclude, sir, anything else?
There are 2 questions in the chat box which you can quickly take. Now we are running, we have to be closed, and I'll give a final request to all the panelists to express in 1 minute each. So 2 questions are in the chat box, you can take it up.
One is how to take the fees directly from the patient or through hospital. What does this have any legal implications? What is the better way?
See, fees is a fees, whether it is received directly or through somebody legally liable. Legally liable because fees is received by you only. Whether a fee receipt has been given or not, that and all immaterial. If you have received the fees automatic, then every court will accept that a fees has been paid to the anesthesiologist. So that doesn't make any difference.
If you are a freelance practitioner, it is better to take directly from the patient. So there is no intervention of other party.
No, directly means, sir, what I want to convey, if a person is going to assist a surgeon, the surgeon may collect the fees and give it to him. So legally, it is same. But out of the purview, I can say some people will be worried whether the surgeon has collected more and has paid less to the anesthesiologist. That and all different. But a fees has been received because we are now talking about legal issues only. So whatever it is, money is received means money received. That's all.
Yeah, but as a private practitioners, we have been fighting that we should take the fees directly from the patient.
Yes, yes.
Patient should pay it directly. That's a good welcome thing. Absolutely no. Bharat is
different.
Bharat, your question is Bharat Paliwal, Dr. Bharat Paliwal, that with the new blocks coming up, and can it be blamed on us that you could have done this case under blocks rather than GA? See, you are the best person to administer anesthesia. It is your choice. You are free to choose the technique with which you are most comfortable with and which is the best for that patient. So absolutely no issues for that. With this, I invite, I can see Dr. Baljit Singh sir on my left hand on the screen. Sir, final comments from you.
Well, Dr. Naveen, it was a great webinar, very, very interactive. I think that was the best part of it. A lot of participants who were watching or who were there on the screen, they were interacting. And personally, I would say that I've learned quite a few things with regard to medical legal issues related to the patients and, if there is some untoward event that happens. Thank you so much for having me in this discussion. Thank you.
Thank you, Dr. Naveen.
Dr. Parekh sir, final comment from you.
No, final comment is that I myself learned so many things. That is the advantage of this session from Meenakshi Sundaram and Baljit and everybody. Whosoever spoke, there is something new which I did not know. So it was very educative for me also. Thank you very much.
Anjali Bure madam and then Dr. Arun Sharma. And there are young studs also. You can also express yourself. Dr. Anjali Bure madam.
Yeah, it was a great learning experience, Dr. Naveen. And I think many practical aspects were discussed. So that is going to be beneficial to all of us. Thank you so much.
Thank you. Arun?
Yeah, thank you, Naveen, for making me a part of this. And I enjoyed every aspect, every minute of the discussion. And as everybody said, there were a lot of things which I also learned during the discussion. We should have more of these sessions. We should talk more about our safety. We normally talk about patient safety. These sessions are meant for our safety, and we should have more of these sessions.
Good.
Thank you. We'll definitely have. Deepika, you are on the other side, a younger one. And what's your feedback?
Thank you so much, sir. We definitely have learned a lot from all the esteemed panelists and speakers. Thank you so much, sir.
Oh, in addition to thanks, Neha, any other critical suggestions or comments?
Thank you so much, sir. Actually, because all of us have started with our careers, so having knowledge about all these things beforehand is going to be very, very helpful, especially for us, because we are going to face a situation somewhere near in the future. Everyone usually does. So I think I'll thank all of the panelists for giving us such valuable experiences from their own experiences and everything. Thank you very much, sir. Thank you, Naveen sir. Thank you, everyone.
And Dr. Amit Rana?
Thank you so much, sir. And I would like to thank all the panelists for such information. Thank you.
Good evening, sir. Sir, this session was very informative. In fact, both the sessions were very informative. So many aspects are touched, and I think so many aspects are left also. So I think these kind of discussions should go on in future also. Thank you so much to all our panelists to enhance my knowledge. Thank you, sir.
Before I invite Dr. Mahesh Sinha, sir, Vice President ISA National, to formally give the concluding remarks and close the session, I'll thank all the panelists and Mr. Rahul Chaubey from Anesthesia TV for streaming it live on the YouTube, Anesthesia TV and Facebook. Thank you, Mr. Rahul. Over to you, Dr. Mahesh Sinha, sir, for your concluding remarks and concluding the session.
Thank you, Naveen, for conducting a very important issue and taking up to the members. I think we need a regular updation on this avenue also, because this is also a changing scenario. That newer things are coming and everything changes with the time. So a lot of things like in the West, the people are now the gaseous anesthetic agent, they want to go away because of the pollution. And as one question asked about the blocks, actually, whether the block, if you have not, why you have not given block, why we have given GA. It may not be important today, but I think in the future, when this becomes common, naturally it will be a big question mark. Thank you. Thank you for the opportunity. Good evening.
Right. Bye. Thank you, everyone. Bye.
Thank you, everyone. Thank you. Thank you very much.
Bye-bye.
Night, everyone. Thank you.